Velázquez v. Bondi is the first one out of the Supreme Court on April 22nd, 2025. This is the voluntary departure one. It's a kind of silly but consequential decision, and it was good for non-citizens. I wouldn't recommend waiting until the last day, but if you do, you're okay. With voluntary departure, you avoid a removal order. This is what Justice Gorsuch says for the majority. Quote, for the government, an individual's voluntary departure saves the cost and effort associated with detention and removal. For the individual, it not only allows him to choose how and when he leaves the country, it also allows him to avoid substantial penalties associated with forcible removal, end quote. Really a 10-year bar to removal, right? Voluntary departure can be a good thing. If you just don't want to be here anymore, you have a weaker claim, and especially if you have a future path to coming here, as you know.
Yeah.
But what so often happens post-conclusion voluntary departure, you lose your application in chief, be it asylum, cancellation of removal, what have you, and then you get voluntary departure, usually for 60 days. And when you appeal the denial of relief in chief to the BIA, I'm not sure if they have to, but they always give you 60 days again to voluntarily depart at the end of the BIA's dismissal of your appeal should you lose again. But by regulation, and don't quote me on it, but as the decision explains, by regulation, if you file a motion to reopen with the BIA within a certain period of time, you can avoid the removal order as well. You can retain your voluntary departure while the motion to reopen is pending, I believe. Here, it was filed and actually served on ICE timely, the copy of it. But it was still a mailed case. I mean, these type of decisions will become less and less frequent as we all go electronic. But here it seems that the deadline fell on the weekend. And it's possible, actually, I don't even know, that this individual filed their motion and the BIA received it on the weekend. But the BIA is never going to stamp it in on the weekend. They don't stamp things on the weekend, as I understand it. I don't know what actually happened here. But in any event, the deadline was on the weekend, and then they received it the next Monday. In pretty much every other area of law and many other areas of immigration, that's a timely filing. If a deadline falls on the weekend or a holiday, it goes to the next business day. But the BIA said, no, that's not how it works with a voluntary departure motion to reopen. And so your motion is automatically denied, and that voluntary departure just became a removal order. It's rough, right? And the 10th Circuit affirmed that. But the Supreme Court did not.
I think USCIS, if it's weekend, it goes to next Monday. That's already established USCIS policy.
I'm almost positive that's the case with everything with USCIS, but I try not. Only a Sith speaks in absolutes, but I believe that's the case with USCIS. But that's one of the things the Supreme Court majority relied upon. That's generally the case in immigration going back 70 years, and presumably Congress, when they're writing their statutes, which admittingly this was ambiguous, they know what they're doing, and they bring that in with. We're not talking calendar days, we're talking business days, says the Supreme Court majority.